Welcome to the bonus holiday edition of For the Defense. I'm your host, David Oscar Marcus. I hope everyone has a healthy holiday season. And back to the podcast, in the first season, we covered lots of blue-collar crimes, murder, sex offenses, even a drug offense in federal court. This episode deals with a white-collar crime. There's no violence, there's no drugs, there's no sex. White-collar crime generally deals with fraud, businessmen, professionals, corruption, like public corruption. And this is really my specialty. I handle lots of white-collar cases, and I currently teach white-collar crime at the University of Miami and previously taught it at FIU. This episode was actually recorded during my class this past semester, where we had Hank Asbill as a guest. And we're going to speak to Hank about his representation of the governor of Virginia, Robert McDonnell. And back in 2014, Governor McDonnell and his wife were charged with corruption charges for receiving all kinds of gifts from a Virginia businessman named Johnny Williams. Now, white-collar crime isn't like a bank robbery, for example. Everyone knows that robbing a bank is criminal. So at a trial for bank robbery, the defense is generally SODI. Some other dude did it. That's not true in a white-collar case. In white-collar cases, many times, the defendant will agree that he did the actual act, in this case, receiving the gifts. But the defense will be either, one, that's not a crime, or two, I didn't think what I was doing was a crime or criminal or bad. That latter defense focuses on the intent of the person. And you'll hear from Hank now about his defense of Governor McDonnell. And he'll say and explain that, yes, McDonnell and his wife got lots of gifts, money, and other items. But the question at trial, and all the way to the Supreme Court, you'll hear, is whether he did an official act in exchange for those gifts. Did he do anything in exchange? The pro quo and the quid pro quo. Certainly there was a lot of quid, as you'll hear Hank say, but was there anything in return? Johnny Williams testified for the government that there was, but Hank and company argue against it, go all the way to the Supreme Court, and you'll hear what happens next in For the Defense. So Hank, let me introduce you to the students. This is Hank Asbill on the Zoom call with us, everybody. Hank is like the man to see in the white-collar criminal law world. And he's an awesome lawyer. He's been saying basically, fuck you to the government for how many years, Hank?
40-something.
Yeah. I've only been doing it for 20-something. So you've got a lot more fuck yous in you than I have. And I started out telling the class that I was going to be formal with you. And this is how we've started out. Hank had the really cool experience of representing the governor of Virginia, Robert McDonnell. And I'd like to speak with you today, Hank, about that representation, how you came into the case all the way through trial up to the Supreme Court. So why don't we just start at the beginning? I mean, you don't get the first call when the indictment's handed down. You represented the governor for a while before indictment. How did you get involved in the case?
Well, yeah. In 2013, there were starting to be around the March timeframe, Easter timeframe. There started to be a lot of news reports or leaks of a grand jury investigation that were reported by the Washington Post and some of the Richmond papers about a grand jury investigation of Governor McDonnell relating to his relationship or supposed relationship with a guy named Johnny Williams, who was the CEO of a publicly traded company called Star Scientific. And the theory in the releases, basically, the grand jury leaks, was that McDonnell had somehow been bribed to give official act favors to Williams. When those reports started to come out and the governor became aware of the grand jury investigation, he initially lawyered up. He and his wife were both initially represented by Williams and Conley. Williams and Conley was not interested in interacting much with the government. It's just not their style. And as a result of that, the governor brought in an old friend of his named, John Brownlee, who had been the U.S. Attorney for the Western District of Virginia And when McDonnell was running for governor, Brownlee was simultaneously running on the Republican ticket for attorney general. So the governor had brought Brownlee and Holland and Knight in. So the governor reached out to friends at Notre Dame, where Bob had gone to school, was on the board, et cetera, and close friends with a lot of the top administrators of Notre Dame, and asked them for recommendations for additional counsel or lead counsel. There's a very strong connection between Jones Day, where I was a partner at the time, and Notre Dame. And so anyway, that connection to Jones Day was discussed, and that's how I got into the case.
We'll forgive you for the connections to Notre Dame, since we're all Miami people here.
Yeah. Well, I didn't have any personal connections to Notre Dame, but in any event, the chairman of our firm did. And the people at Notre Dame asked Jones Day to come in and help McDonnell out or help figure out what was going on. And in that vein, I got asked by the chairman of the firm and by McDonnell to take control of the case.
So, Hank, when you come into a case like that, I mean, there's so many things to get your arms around. One is when you represent a high-profile client like the governor, that's difficult in itself. And then a high-profile prosecution, a lot of times prosecutors won't even speak to defense lawyers in that situation. Were they willing to talk to you and tell you what they were looking at, or did they say see in court?
No, they were willing to talk to us. They gave us a reverse proffer to try to convince us that McDonnell should cut his losses and take a plea. That went nowhere, and it went nowhere with his wife and her counsel as well. But they were willing to talk to us about it, and ultimately we got an audience. We insisted on an audience with the Deputy Attorney General, Jim Cole, and with the head of the Public Integrity Section and other lawyers associated with the case. And ultimately, prior to the indictment, we got an audience at Main Justice in December of 2012, right before McDonnell was indicted in January of the following year. That exercise went nowhere either. We tried to convince the people at Main Justice and the locals that they didn't have a case based on agreed upon facts, that they misunderstood the law in terms of what an official act was, and their theories were wrong about legally what constituted an official act. And we basically told them that, no matter what happens, if you indict, if we go to trial, if we lose in the Fourth Circuit, the Supreme Court is going to take the case, and you're going to lose 9-0 in the Supreme Court.
Well, you were off by one. I think it was 8-0.
No, I was off by 2. If Scalia had lived, it would have been 10-0.
So when you meet with DOJ and they're making plea offers, what did they offer you at that point?
Well, the actual offer was never made public. There were news reports that were leaked by the government about what the offer was that were wrong, that were not as harsh as what the government wanted him to plead to. But the bottom line was that if he was willing to plead to bank fraud charges, they were willing to drop the public corruption charges that they were intending to bring, and they would let his wife go. And anyway, but they were going to, obviously, in connection with trying to get him sentenced, they were going to outline all the public corruption evidence that they had, regardless of whether the charges were actually brought or he pled to them.
I've seen more and more the government doing this where they say, if you take a plea, we will not prosecute a family member like a wife or a child. What do you make of that strategy that DOJ is employing in trying to get people to plead guilty?
I find it to be tremendously offensive. Maureen McDonnell was collateral damage in this case. The only reason that she was charged, there are two reasons. One was to make it more difficult for her to be a witness for her husband. And she had a lot of exculpatory evidence to provide that if she were not charged, would have been much easier to access. And they wanted to leverage him and try to, play the, you got to be the Virginia gentleman, basically, and you should take a hit here and keep your wife out of the crosshairs, despite the fact that most of the evidence in the case related directly to the wife's relationship with Johnny Williams. I found it to be very offensive, very problematic, and I think it's unconscionable as far as I'm concerned. Although obviously Maureen McDonnell did have a lot of interaction with Johnny Williams. You could have theoretically charged Maureen McDonnell with conspiring with Williams to try to get her husband to perform official acts for Williams, even without charging the governor directly. But they didn't care about Maureen McDonnell at all.
And of course, she never took an official act anyway.
She can do whatever she wants. She can stand on the street corner for $1 million an hour and hawk Johnny Williams products. She's not a public official, and she can do whatever she wants in that regard.
So maybe this
is not a conspiracy with her husband.
Right. So maybe this is a strange question, but if she never spoke about any of this with her husband, could she have been found guilty of any of the crimes or no?
Well, I mean, theoretically, I guess if she and Johnny Williams conspired to bribe McDonnell to get him to perform official acts, whether or not they ever followed through on it, they would have potentially been able to charge both of them with a conspiracy.
Okay. And so, it is strange though, because in most cases, especially when a family member is charged, there's this sort of embracing of each other and providing a unified defense. This was the opposite, it seemed like, although I don't know if you can talk about whether it was a joint defense or not, but at least both sides were shooting arrows at each other at the trial.
I don't view it that way at all. I mean, to begin with, in terms of the alleged plea offer that really didn't exist in the form that was reported, everybody in the family, all the governor's 5 children and his wife, and all the relatives agreed that there would be no plea. There was no way that Bob was going to admit committing a felony, give up his license, exit the governorship in ignominy. That was not going to occur, and nobody in the family wanted it to occur. And in terms of the strategy at the trial, there clearly was a joint defense, and the essence of the joint defense was to tell the truth, basically, about what happened, what the relationships were between husband and wife during this critical time period, and what exactly the governor knew and didn't know relating to Johnny Williams. And that was the plan to begin with, and it was agreed upon by counsel for both the governor and his wife.
Hank, maybe I jumped the gun. When you speak of reverse proffers, that's when the government tells the defense their theory of the case and why they think they're going to win. What was their theory of the case before we get into the weeds of the defense and everything else? What was the government's theory of the case?
The government's theory of the case basically was that in return for gifts and loans to McDonnell and his family from Williams, the governor agreed to try to get the state government to conduct trials, clinical trials at Virginia medical schools for Johnny's product, Anatoblock, which was a nutraceutical that supposedly dealt with inflammation issues. And Johnny was trying to get that, he claimed he was trying to get that product approved by the FDA so he could make a lot more money. His company could make a lot more money marketing it as an approved drug as opposed to a nutraceutical. So that's the government's theory, was that trying to help Johnny get his product FDA short-term approved by the
and when
effective by the Virginia medical schools and clinical trials, that was their theory.
And Hank, the way he was trying to do that, the government said, was through giving gifts and loans, and I think they in their opening they showed the picture of the Ferrari, and they certainly leaked that to the press. But all those facts were agreed to by the defense, I assume, right?
Yeah, I mean, there were variations on that theme. For example, there were discrepancies between what Johnny Williams claimed and what the wife claimed and what Bob claimed about the Ferrari, for example. At one point in time, Williams offered to let the McDonnells use his house, his vacation house at Smith Mountain Lake for a 3-day vacation. And as Bob understood it, Johnny had a Ferrari there in the garage that he wanted to have back in Richmond. And so the message to Bob at the end of the 3-day weekend was, would you do me a favor and drive the car back to Richmond for me? And Bob thought that that would be fun to drive the Ferrari a couple hundred miles back to Richmond, and that's what he did. This was not something that Bob thought of or knew was lined up as some sort of a perk by Williams for Bob in return for Bob performing any kind of official act or putting his thumb on the scale of anything that the Virginia government might do or might be able to do. So there are a lot of there are a lot of twists on those things that they didn't come out exactly the way the government thought they were going to come out. Same was true with other gifts. For example, Maureen McDonnell got $20,000 worth of dresses, coats, etc., from Johnny Williams, which she never told her husband about. She hid in the mansion, in an office, basically, told her daughters about it, that she had gotten the stuff from Johnny Williams, but neither the daughters nor Mrs. McDonnell ever told Bob anything about the dresses that Johnny had bought from Maureen. So I mean, that we agreed on the facts essentially in terms of the basic core of the facts, but not about who knew what when or who was involved in the issues relating to the gifts and the loans.
Is a governor and his wife receiving those gifts a federal crime? We'll find out in For the Defense next. Pictures of Ferraris, wives getting dresses and coats and money. I mean, doesn't look good if you're a governor and that's what's going on. But the question is whether that's a crime, not whether it looks good or bad. And that's part of the problem with criminal defense and the trials these days. In a civil case, there'd be depositions, motions for summary judgment, and the law would get tested. In a criminal case, however, there are no depositions. There are no motions for summary judgment. It's basically you go to trial or you plead guilty. And that's why so many cases plead guilty, because the risks are so high and you don't get to test the law unless you're willing to go to trial, get sentenced, and take it up to the Supreme Court. Governor McDonnell had the guts to do that with a great lawyer like Hank Asbill, and you'll see what happens in For the Defense next.
But, in a lot of these white collar cases, and this one's no different, those images, the image of your client in a Ferrari or, with wealth, prosecutors use that so often, even if there's no bad story around it, because the image of wealth itself, they think, is going to have such an impact on the jury.
Yeah, particularly for a public official.
Right.
To be driving a Ferrari, to get a Rolex, essentially, to have high-end vacations, play golf at exclusive clubs, etc. But the real interesting thing with respect to that is that every governor who preceded Bob had taken from various businessmen in Virginia an equivalent amount or nearly equivalent amount of gifts during the course of their tenure as governors. So this was not unusual. Everybody, the other governors had all taken gifts from various people, not as concentrated with a single individual donor like Johnny Williams, but the total of around $150,000 was something that was commonplace in Virginia for governors to accept during their 4-year terms.
So the indictments returned, do they arrest the governor? Or do they let him surrender?
No, they let him surrender. But the issues leading to the indictment were sort of interesting. The government didn't want to, was afraid to indict McDonnell in the fall of 2013 because he was still serving his term as a governor, number one, and there were interim elections in November in Virginia. And DOJ policy is not to bring public corruption indictments on the eve of elections for fear of supposedly influencing those elections one way or another. So the government was going to hold off until Bob's term expired on the 12th of January, 2013, before they returned an indictment. But we knew after the meeting with Main Justice at the end of December that they were going to go ahead and indict. We just didn't know exactly when. I told the lead prosecutor that I don't really care when you indict. We'll show up whenever we're required to show up in court. But do me one favor, and that's to not do anything during this particular 5-day stretch in late January around Martin Luther King Day, because my wife and I had planned to go to Petty St. Vincent on a 5-day trip for her birthday, which was the 22nd of January. So the prosecutor said, don't worry about it. I won't do anything while you're gone. And that's exactly what they did.
Oh my God.
I went to Petty St. Vincent with a cell phone, my wife's cell phone, and a satellite phone to make sure that if anything happened while I was on this brief vacation, that I would know about it. And I got a call sitting on the beach in Petty St. Vincent from the lead prosecutor saying that they had just filed the indictment. And they then dragged their feet on trying to get the court to schedule the initial court appearance. I asked, this was on a Tuesday when they returned the indictment. And I said, fine, why don't you have the initial court appearance on the following Monday, because I'm scheduled to come back on Saturday from the island. And they couldn't convince the magistrate judge and the district court judge to push things past Friday. So with great effort and at great expense, a boat, a car, 3 planes, and leaving my wife in Petty St. Vincent, I got back to Richmond on the morning of the first court appearance on that Friday. And I had to eat this in above the fold in the Washington Post and a lot of law journal articles. It's like, where in the world is Hank Asbill? And they had pictures of camels crossing the desert and trying to figure out why I wasn't at my office and where the hell I was, et cetera. And they never could quite figure it out. But nobody, the judges and the prosecutor, were not really willing to push it past Friday. In the meantime, the governor, on the day of the indictment, surrounded by his wife and 1 or 2 of his children, gave a press conference in the lobby of the Richmond law firm that was representing one of his kids. So he gave a brief press conference on that same day he was indicted without any attorneys present. Obviously, we knew he was going to say something when he was indicted, and we were well aware of, generally speaking, what he planned to say. And obviously we wanted to be cautious about that. But, he had an absolute right to respond to the indictment himself, and that's what he did.
But Hank, did the prosecutors tell you why they had to do it while you went away, or do you think they did it on purpose just to mess with you?
Well, they obviously did it on purpose, and it did mess with me. You can connect the dots, but they knew I was going away. They had committed to not doing it while I was away, and they did it.
Yeah. And so that sets the tone. So do you have motions ready to file that when you get back?
Yeah, well, the first thing that we had to do, we did. We had motions prepared, our day one motions, as we called them, that were drafted and ready to go. 2 motions. One was accusing the government and asking for an order relating to Brady material, because we were convinced from our interaction with the government that they really had no clue what was Brady and what was not Brady, and misinterpreted things that we thought clearly were Brady. And so we knew we were going to get shortchanged on that front. And the second motion we had prepared was a motion basically to require the government to produce the legal instructions that they gave to the grand jury in order to secure the indictment, because we were convinced, again, that they had no clue what the law really was relating to official acts. So therefore, they were going to misinstruct the jury, the grand jury, about the elements of the offense. And we wanted access to those instructions to support a motion to dismiss the indictment on the grounds that they had misinstructed the grand jury on the law. So those motions were very aggressive in terms of the language and their content. And we obviously knew that those would be picked up on by the press immediately. And they were. And this is after Bob has his own press conference. The motions are filed literally within 30 minutes of the indictment being given to the press and given to the clerk's office by the government. Bob got up and said that he never promised and Williams never received any government benefit of any kind from him and from his administration. We basically argued, not in the Brady motion, but in the asking for the legal theory communications between the prosecutors and the grand jury. The opening quote read, "It's been a long time since the Roman Emperor Caligula imprisoned people for violating laws written in tiny lettering on a pillar too high to see."
Great. I love it.
So that was that's the kind of language that was in those opening motions. So anyway, this is our response to the 6 months worth or 8 months worth of grand jury leaks and the government's press conference, et cetera, and their announcements about the indictment. So anyway, this is our response. Bob gets up and says something himself alone. We file these motions. We then come into court on that Friday for the bond hearing and then the arraignment in front of the district court judge. Interesting, at the bond hearing, we were assigned to a magistrate judge whom I had had a prior experience with 20 years earlier. That was the only time I'd ever dealt with him when he was in AUSA. And that prior experience is sort of worth noting because it gave me an absolute locked ground to recuse him that I chose not to employ, but I had to make an executive decision about whether or not I was going to move to recuse him. But the essence of the prior interaction, so anyway, I'm now faced 20 years later with this magistrate judge who starts giving me shit about, you guys, we have very strict fair trial, free press rules here. I'm going, yeah, I'm well aware of what the rule is. What's your point? He says, well, your client had a press conference. I'm going, yeah, what's your point? He said, your client said this and that. And I said, yeah, what's your point? And he said, well, lawyers can't do that. I said, he's not his own lawyer in this case. He happens to be a lawyer, but he's a defendant, and he's got a First Amendment right to say whatever the hell he wants. The rule does not apply to him if he's not the defense counsel or a pro se defendant. So anyway, we got into arguments along these lines, and then the guy is going, well, I'm going to order the governor not to talk to any potential witness in the case. I said, he lives with one of them.
Right.
His wife, his children, all his cabinet officers are all witnesses in this case. That's a ridiculous restriction. We're happy to not have him talk about the facts that are related by the government to us in the indictment. But other than that, we're going to talk to friends and relatives, period. And this magistrate, well, you're the only defense lawyer I've ever met who wants his client to be able to talk to witnesses. And I'm going, yeah, well, okay. So anyway, I was on the verge all through this hearing of moving to recuse him. Chose not to because it's a small court. The prosecutors and the judges are all in judges, and they interact with each other to create waves if I didn't have to begin with. Anyway, we get the bond conditions that we want, and then we go to the district court judge, and the first words out of his mouth are, the game playing with the press stops now. But he's looking at both the lead prosecutor and me, not just me alone. And so we didn't really respond to it, basically. But that was the end of our trying to interact with the press from that point forward.
And so, as you move past that bond hearing and the initial hearings, You then have to get ready for trial, and I assume the trial prep has been going on for a long time already. What kind of
Not really. I mean, not until we saw the indictment and got the discovery. And, we were in court at the end of January, and the judge sets a trial date for the beginning of August, 6 months away.
Right.
Which in any other jurisdiction would have been, the trial would have been a year and a half away, not 6 months away.
And are you able to do some mock juries or focus groups in those 6 months, or it's just too tight of a time?
Yeah, I mean, we certainly had time to do that. I mean, we had to plow through the discovery first, and the discovery basically, I mean, there were millions and millions of pages of discovery that were produced, and they were slow rolled to us. The government wasn't ready to give us everything we were entitled to immediately, like they were supposed to, and they then gave us a lot of the documents in a format, some stupid FBI format called BidMass that I'd never heard of before, that made it impossible to access these with any degree of specificity. But we got over 5 million pages of documents and ultimately about 185 302s of witness interviews. We were conducting our own witness interviews. We interviewed 49 or 50 people ourselves, and we filed 33 pretrial motions. All this was done in that time frame between the end of January and the beginning of August.
So what kind of jury do you end up looking for when you have the governor of Virginia, of the state you're trying the case in? Do you have a specific jury you're targeting, or what are you looking for?
Well, it's interesting. That's an interesting question. The first issue was whether or not we should move for a change of venue, because theoretically, in a public corruption case, every citizen in Virginia was a victim of the crime.
Right.
But we also had Quinnipiac polls. McDonnell was a very popular governor, and even he had a 65% maybe approval rating to begin with. That didn't drop below 60 even after the indictment. And so we thought that if we got a reasonable voir dire, a fair voir dire, that staying in Virginia would be better than trying to move the case somewhere and not getting any reasonable voir dire. So we were, that was the threshold decision is do we move for a change of venue? And I didn't want to. I wanted to try to really get into the voir dire and try to find jurors who could be fair and reasonable regardless of whether.
Can you get a reasonable voir dire in federal court? We'll find out in For the Defense next. So in state court, when you do voir dire, which is the process where you're questioning the jurors about whether they can be fair or not and trying to find jurors that are suitable for the case. Of course, each side is fighting for jurors that they think will rule for them, but the idea is to weed out jurors that are unfair. So how do you do that? In state court, you're generally permitted lots of time to question the jurors, lots of time in a high-profile case to see their answers on a written questionnaire, and so on. In federal court, you're lucky if you get 10 minutes for the entire panel. So if they bring in 60 or 70 jurors, you get 10 minutes to question all of them. It's almost impossible to find out who would be unfair or who would be favorable or any of those types of things in that sort of situation. And the voir dire process in federal court has been roundly criticized. But federal judges want to move their cases along. They don't want the gamesmanship of the lawyers trying to get jurors to be pre-tried or on their side. So they severely limit the lawyers from questioning. And you'll see how the federal judge in the McDonnell case does that in For the Defense next.
And did the judge give you a reasonable voir dire?
No, he didn't. He didn't. And in particular, I mean, we both, the government and ultimately we and the government agreed to a questionnaire. The judge eliminated about half of the questions, rewrote some others to his satisfaction, and sent out this watered down questionnaire. He then followed it up with an in-court voir dire covering a lot of the things that had already been covered in the questionnaire unnecessarily. And when we got to the issue about pretrial publicity, that's when we really got screwed. Ultimately, the government, our combined belief was that if people had been exposed to the press in this case, directly or indirectly, they had to be interviewed one at a time. They had to acknowledge what they had read or heard or seen, et cetera, what they had discussed, what they remembered, how many times, how often, does it really stick in your mind? And ultimately, the question is, did it cause you to form any opinions, one way or another, about the outcome of this trial? Is McDonnell guilty or innocent? Have any of this impacted any opinions that you might have going into the trial? The judge basically, he understood that was going to prolong the voir dire because virtually every one of the 200 people that were initially brought into the courtroom as a potential panel, had been exposed to the press, which was voluminous and constant on TV and everywhere else. And almost all of it was negative, hugely negative. So basically, I'm asking, and the prosecutor's agreeing, that we got to interview these people. And the judge goes, I'm not doing that. And he literally says, I am going to do something in my own invention. And I thought to myself, this is wonderful. I don't know what he's going to do, but it sounds to me like I've already got a great issue on appeal.
Right.
So what he invents is everybody back there in the well, the court, all 200 of you, if you'd have been exposed in any way to press or anything else, or have any knowledge about this case, stand up. Everybody stands up. Because if you can't be fair, keep standing. Everybody sits down. Then the judge looks at me and says, so there. And I'm going, this doesn't work for me. And here's a list of 10 questions that I want you to ask each of these people. And the judge, says, no way I'm doing that, basically. And so we went from there and did the best we could. And we had jury consultants. The government had jury consultants. And we did the best we could under the circumstances to try to identify people that we thought were hugely toxic.
Right.
And get rid of them. And then we're sort of stuck with the remainder. As it turned out, ultimately, initially at least, we did have 2 jurors who were strongly favorable to the defense, but they didn't last through the trial. So we ended up without those 2 that I think would have either convinced the jury to rule otherwise or at least have hung the jury.
Hank, let me ask you, trials are so much like theater, and every appearance matters, how the client sits, interacts with the lawyer. In this case, there was so much reporting about the governor's interactions with his wife, just walking into the courthouse, sitting in the courtroom apart, not really interacting as husband and wife, but very far apart from each other. I trust that was all planned out.
Well, it was planned out, but by the time of the trial, Bob was not living with his wife. He was instead staying. His wife lived outside. They had a house outside of Richmond, 30 minutes or so from the courthouse where they had both been living. They obviously were having problems in the marriage, and this was the fact of the indictment and the rest of this was very stressful on both of them. So Bob moved to Richmond and was living in the rectory of his priest's, his priest's house at a parish in Richmond. And that was by design. Number one, Bob was working with us until midnight every night. And so we wanted to have easy access to him in Richmond, number one. And number two, if he had gone home every night, there would have inevitably been arguments, debates, interaction that was non-productive or would not be good for either defendant to have that kind of stress overlaid on top of a stressful marriage. And so the idea of keeping them separated was important, but it was also the truth of what their relationship was at the time.
Sure.
So it was not staged in that sense. It was not feigned. It was legitimate.
But, you mentioned something that resonated with me, which is working till midnight every night, getting up at the crack of dawn during trial. It's really, when you're in trial, it's a 24/7 job, and you get no sleep, you don't eat well, you're stressed to the max. I don't think people really get it. And this was a 5-week trial where everything you did was scrutinized. It wasn't even just the regular stress of a trial. I mean, how, just to put aside this, McDonnell for a second, how did you deal with the stress, and how did you deal with having to basically close your practice for all those weeks and deal with a case like this?
Well, I was at Jones Day at the time, and they have 2,700 lawyers. So the rest of the practice basically could be put on hold, and other folks could help out and keep things up in the air until I got through with this. And I had tremendous support. I took 5 lawyers with me down to Richmond, and the Holland and Knight people had an equivalent team, and the Quinn Emanuel people had an equivalent size team. So we had 15 or 18 lawyers at a hotel in Richmond, and I had 5.
Who paid for all that?
Big one. Theoretically, the clients are supposed to be paying for it, but the fact of the matter is the clients are still behind in terms of payment. So, they had some money, and a lot of that went towards expenses, and some went to fees. But the fees were enormous, or would have been enormous in the case if they had been ultimately collected. But the chairman of my firm, having agreed that we would take on this case, was like, do the case, do the best you can. We'll worry about the money later. And McDonnell had the proven ability as a governor and head of the Republican Governors Association. He raised $50 million in 1 year for Republican governors around the country. And he had a lot of wealthy friends who were donors, and he had a lot of friends in the Notre Dame community who also had a good deal of money. And so we were ultimately convinced that at the end of the day, Bob would figure out some way to make good, but it was his responsibility to pay for his children's lawyers, his wife's lawyers, his own lawyers, etc. But in any event, I also had 5 people working back in the office at Jones Day that were going over transcripts daily, coming up with motions, coming up with ideas, etc. So it was a big operation. But in terms of how I dealt with it, I just sole focused, and I slept about 4 hours a day. I tried to get, about an hour's worth of exercise every day. But that's it. There was no day that was less than 16 hours, and many were 20 hours.
Right.
And it takes stamina. But the real problematic overlay here was the press, which created hassles and problems every single day for us, including camping out in our hotel. So if you went down to dinner with another lawyer in the case and you wanted to talk about something relating to the case, you had no idea if the guy at the next table was a reporter or not, unless we just happened to recognize them. But there were, 20, 30 reporters who had rooms at the hotel. And we didn't know who many of these folks were. But so anyway, there were spies everywhere. We had a big war room and a conference room where we could get, buffet dinner at the hotel if we wanted to just work through dinner. But there are people, outside of the rooms, outside of your own room. If you're talking to the governor in a suite in the hotel, there are people in the hallways.
That's insane.
And the minute you leave to go to court, you are followed by a rugby scrum of reporters who literally, just surrounded you, 50, 60, 70 reporters on the 2-block walk to the courthouse, and from the courthouse, sticking microphones in your client's face and throwing questions at him. And you're sort of shuffling along, but they're literally physically assaulting the lawyers, trying to push them out of the way to get face-to-face with the client. The good news was that because he was a governor and a politician, he knew how to deal with the press. He knew how to deal with that, and it wasn't all that disconcerting. But the judge would not put any restrictions on the press. He wouldn't give us like a a blockade gate or something in front of the courthouse that the press couldn't pass. He was unwilling to employ any kind of strategies to and from court. So we lived with 45 minutes early because it's going to take 30 minutes to get through the rugby scrum and to get through the marshals. So in any event, you just sort of have to adjust. And we had sandwiches and stuff delivered to the courthouse for lunch. And
right.
So anyway, that's how we dealt with it. But and then finally, ultimately, in terms of getting work done at night, Bob, he's a great client. I love Bob in a lot of ways, but he's got the trifecta of problems for a client. He is a lawyer, he's a chief executive, and he is a politician. And those are difficult things to deal with in a client. And he would like to, run around the room, the war room at night and talk, what are you working on? And what about this? And what about that? And wouldn't it be better if we did this? Wouldn't it be better if we did that? Finally, I just, I had to sort of make it clear to Bob. I said, there are two things that you have the right to control. One is you can testify or not, and the other is you can plead guilty or not. All the rest of the calls are mine. And I know you've got ideas, and some of them are great, et cetera, but you're interfering with all the assignments that we've given out to people. So I tasked one associate who reminded Bob of one of his daughters to go sit in the corner with Bob, take all of his questions, advice, suggestions, et cetera, and then distribute them at some relevant time to the people who were working on those issues. But I said, you can't keep disturbing everyone who's working on something in the middle of what they're doing all night long. But he would have worked without stop, and slept 1 hour a night.
Unbelievable.
As a governor, that's what he did. He worked 16-hour days for 4 years as a governor.
Did Governor McDonnell actually help the defense team? We'll find out in For the Defense next. So yes, many white-collar criminal defense lawyers talk about the challenges in representing other lawyers or politicians, or even in general, white-collar defendants who are smart, who have built up success and money, and they believe that they can persuade a jury themselves, or that they know what's best for the defense. So yes, in some ways and in some times they are challenging, but I'll tell you a story of a challenging case that I had, a challenging client. I had just left the public defender's office. Literally the day I was moving my office into my new office, I was in jeans and a t-shirt. And at the time, Chief Judge Moreno called me into court, and I went. There was a packed courtroom. Chief Judge Moreno asked me in front of everyone, now that you've left the public defender's office, do you still believe in the Constitution? Everyone laughed, and I laughed, and I said, of course, Judge, why? What's up? He said, meet your new client. And there, sitting there in handcuffs with 5 marshals around him, was my new client. And Judge Moreno told me he needs a new lawyer because he had just built a knife, a shiv in the jail to kill his then public defender. So you're appointed. We're going to start trial in 2 weeks. I tried to talk to the client back in lockup, and he wouldn't say anything to me. I knew he spoke a little bit of English. He was a Turkish national, and he would not speak a word to me. So I was trying to figure out, how could I gain the trust of this client? How could I meet with him? And it was over the holiday season, just like it is now. And my father-in-law, who was a wonderful man, I miss him, was in town, and he's from Turkey and spoke Turkish. So I brought him to the jail. It was easier to get into the jail in those days. And I brought him to the jail. And for the next hour, he and my client spoke in Turkish. I didn't understand a word what they said. I still don't know what they talk about. But after that, the client referred to me as family and trusted me. So it's just not white-collar defendants who present challenges. All clients you need to build trust with, you need to develop a rapport with, and that was one out there example of how we did it. Let's get back to the podcast and see what happens with Governor McDonnell in For the Defense next.
One of the fascinating parts of the trial to me was Johnny Williams himself, the cooperating witness, what we've been calling in class a lot as the snitch. And what's amazing to me is in reading about the case, I see that he got a complete pass, full immunity to testify, no charges, no plea, no nothing. And that struck me as pretty remarkable in a case like this to give a Johnny Williams a complete pass. Were you surprised that they did that?
Yeah, no, I was appalled. Obviously, the initial agreement with his lawyers was to give him a pass on public corruption-related charges, but then they figured out, because Johnny had good lawyers, that he had a Fifth Amendment privilege because I was going to cross-examine Johnny on unrelated criminal tax violations and securities fraud violations that he was committing simultaneously during the time frame he was dealing with my client. So they had to give him a pass on the tax and the securities fraud violations. And then the government went so far as to do something I'd never seen before. There were 2 shareholder actions filed by shareholders in Star Scientific against Johnny for securities fraud. And those were filed. One of them was in Richmond, another was in, I think, Detroit. Unrelated completely factually to the charges, the corruption charges in the case. And the government was not a party in those civil actions. These were shareholders alone, it's not the SEC or any regulatory agency. And the government went, without our knowledge, to those courts and had the courts stay those cases and freeze those cases because the government was afraid that if the civil discovery in those matters went forward, that I might somehow be able to convince the plaintiffs' lawyers in those cases to share some of the discovery with me that they obtained via that process. And the government was afraid that I could find something that I could use against Williams. So they went so far as to interfere in those other actions behind our back. We filed a motion with respect to that, arguing that the government was interfering with our right to investigate the case and present a defense, basically. And obviously, the undercurrent to that motion was misconduct by the government, which the judge was not about to find unless he absolutely had no choice. Anyway, I had one of my young associates who was anxious for some airtime argue the motion. And the judge looks at it and basically says, he said, if you think that I am granting this motion, you are dancing in fantasy land. Huh. So that was the sort of end of it, basically. But yeah, I thought the government's accommodations of Johnny Williams were absurd. And that ultimately came back to haunt the government at the time of sentencing, when a prior governor of Virginia testified as a defense witness, basically, and trashed the government for their deal with Johnny Williams.
But before we get to sentencing, I want to talk about the cross of Johnny Williams, because he made it seemed on direct, at least from the news reports and the transcript, that he was doing pretty well on direct, and doing what somebody who gets immunity does, which is, make the government happy during their questioning on direct. But then you got on cross and you just got a string of I don't recall answers, which, at least when I'm questioning a witness, I love when I start getting those, because then you've got them. And he even started saying, I don't recall, when you were asking him about a meeting with the prosecutor a couple days before. Really good stuff.
Yeah, he claimed not to remember anything, and he also claimed to have, every conversation he had supposedly was privileged in some way, and he didn't recall anything, obviously on purpose. This is somebody that we were led to believe had a photographic memory in terms of his skill sets. Johnny was not formally well educated, but he was a very smart guy and a super salesman historically, essentially, and a very charming kind of guy. But he, it was, he tried to make himself, and his lawyers helped. His lawyers did a very good job of trying to make him impervious, essentially, to any effective cross-examination, because Johnny just claimed, not to remember, not do it. So in any event, unless you want to bring out a document, laboriously go through it every single time you ask a question with him, you're going to get nowhere in this case, because he claimed not to remember or anything, or claimed that it was privilege, and you have to undercut that in order to go forward. So it just turned out to be, we would have expanded the length of the trial by 5 or 6 days of dealing with Johnny Williams if we went in that direction. Interestingly, the strategy of the Quinn Emanuel lawyer for the wife with Johnny was to just ask Johnny to talk about himself and to just let him run wild. Tell me about yourself, tell me about your career, tell me about everything, that you do, et cetera, et cetera. And that lawyer's theory was that Johnny will just somehow, annoy the hell out of the jury with his grandiosity and with his bullshit and his inability to answer a direct question, et cetera. I wasn't a fan of the strategy, but that was the strategy that the lawyer who went before me on Johnny employed. But it was, I thought basically it was a joke. And at the end of the day, the things that he said that were true were uncontestable. He really had never gotten anything. He had never gotten anything, whatever he claimed he wanted, he agreed he never directly asked for the governor. And he also agreed that he never really got anything.
And that was the key, obviously, to the defense theory. And we'll talk a minute about, unfortunately, you got screwed with the jury instructions, with the district court and how important those were. But, for your case, you end up calling your client, obviously, committed to it in opening. And the governor, I think everyone expected him to testify anyway. How can you not call the governor to testify in his own defense? He was on the stand for a while.
5 days, 27 hours.
It's a long time to have somebody on the stand. He's obviously a very skilled orator. He's people like him, as you said before, but he did get into it with the prosecutor, it seemed like, from reading some of the transcripts. And I saw the prosecutor ended his cross using McDonnell's own inaugural address. He said something like, the scriptures say, to whom much is given, much will be required. And then he asked them about Williams giving him $177,000 in the loans and gifts. How did you deal with that? Did you jump up and ask directly about that line of questioning?
No, that was on redirect. In my recollection, it was on redirect by Mike Dry, and I didn't have any recross. I wasn't going to allow that. The judge would not allow any recross unless.
No, that was of your. That was so that was the cross of McDonnell.
Yeah,
and then you get up to redirect.
I get up to redirect him. No, I had a list of. I wanted to keep the redirect to a limited amount of time, essentially, and just cover some points that I thought were more important than that. But I parked that thought in terms of dealing with that comment. I knew that they were going to use that in closing argument, and I wanted to have a counter to it in closing, which I did. In terms of Mike Dry's, comments about, to whom many is, to whom much is given, you owe much in return, et cetera. And I wanted to turn that around essentially on the prosecutors who have been given a lot of authority, basically, and they're required not to abuse that authority, which we argue that they did.
I always thought that was the Spider-Man quote, and not the not from scriptures. But what do I know? But
well, I had the scripture the scripture quote for Bob in terms of preparing Bob to testify. Is like Matthew 23. Bob was a very religious guy and he read the Bible a lot, etc. And I found there was some Gideon's Bible at the Marriott Hotel in the nightstand of the room that I had. And one night when I couldn't sleep and I'm paging through this, I find this quote. And the basic quote is, the essence of it is in more common language. There are only two answers to every question: yay, yay, or nay, nay. Everything else comes from the mouth of the devil.
Oh.
This is what I kept trying to remind Bob about. I said, if you're not going to listen to me in terms of me telling you what you should do or not do when you testify, listen to God, whom I'm now quoting, because, this is the right recommendation. But it took a lot of, we spent a hell of a lot of time with Bob working on this because politicians like to talk. And, and we wanted Bob to keep it controlled and to answer the questions that were posed to him and not have the judge interfere. And we were very much afraid because the judge had interfered with other witnesses and with lawyers who were questioning witnesses. He had interfered repeatedly. And I did not want to have anything, any sort of arguments with the judge or anything go wrong in that sense. I wanted the judge to be isolated, stay out of my way. Don't get him irritated. Don't get him pissed off. Don't get him chastising me like he had done to some of the other defense counsel in the case when he felt that they were asking stupid questions or repetitive questions or irrelevant questions or whatever. The judge had no qualms about interfering with defense lawyering. He very rarely did that with the government.
It's so annoying when judges do that. It really bothers me.
Well, I mean, for example, one of the key pieces of evidence in McDonnell's direct testimony was an email that he wrote to his wife in the middle of this case, in the middle of his terrible relationship with his wife, talking about how depressed he was about the state of their marriage and how much the marriage had disintegrated. And it was only like a paragraph or two long. And I wanted Bob to read this email out loud to the jury that he'd written to his wife. And he said, the judge said, well, no, that'll take too long or something. And, they can read it if they want to look at it. You can move it into evidence. That was his general theory. Just move it all in. If the jury wants to look at it, they can look at it later. So the way I got around the judge in that circumstance was like, well, I'll try to short circuit it. And I jumped to a sentence in the middle of the email. And I'm saying, Bob, you say this in the email. Tell me more about that. Meanwhile, it's up on the screen.
Right.
And the jury is reading the entire email as I'm focusing on this one sentence. The judge knew exactly what I was doing. And he sort of looks at me with daggers in his eyes, but, he can't really interfere because I have not violated his instruction not to sort of prolong, the reading of the email.
I love it. So we get to closing, Hank, and, by this time, what the instructions are going to be, and it's almost like a directed verdict, but you gave this closing wonderful lines. I'm going to read some of the lines, which is, so we can hear them. But I like the following. You say, Johnny Williams pitches the government this story better than he ever sold a nata block. This is his greatest con. You said the government's trying to turn a party invitation into a federal felony and ignore the attempt to assassinate Bob McDonnell's character with the quid. There was no quo and there was no plan. And that really is the case. Unfortunately, the judge doesn't give the instruction about official act. And so McDonnell and his wife end up getting convicted. The prosecutor asks for some ridiculous sentence. I see 12 years under the guidelines. And you end up getting 2 years, which to me is a huge sentencing win. I mean, how did you feel at the time when you got those 2 years?
Well, let me follow up on a couple of points that you said there in terms of this. He clearly screwed us on the instructions, and it was a directed verdict. And I say that not only because his instructions were found deficient by the Supreme Court ultimately, and they did direct a verdict. And two jurors were interviewed by the press, not by me, after the verdict. And these are people who found him guilty. And one of them said, we asked ourselves, would he have gotten the gifts or the loans if he weren't the governor? And if that was the question at issue in the trial, we were dead on arrival.
Of course.
We were dead on arrival. The other jurors said that, she knew Bob was on the stand 5 days and she believed everything Bob said. And he certainly never said that he committed a crime.
Right.
So anyway, that's that was the end result. As I told you before, when we were talking about doing this exercise tonight, we played this case to begin with to win in the Supreme Court because we were really afraid that we would have trouble with a jury based on the nature of the quid and all the bad press, et cetera. We knew we were going to have problems. We knew we weren't going to get a fair shake in Richmond in terms of sort of standard operating procedures there with the bench. So we were hopeful that we would win a trial, and we tried to win a trial. And obviously we were trying to undercut all of the government's arguments about whether or not there was any quo. And we were trying to focus on Bob's good character, which was exceptional. And we were hopeful that the jury might give us a verdict, or we'd get a hung jury at least. But we were hopeful for an acquittal if we could secure it. But we were assiduously careful of not doing anything during the trial that might negatively impact the potential appeal, because we were hugely confident that we knew what the law was and that DOJ did not, that they'd gotten the law wrong when they indicted. So, for example, when Dr. Hazel testified, the government's strategy was always to play for redirect because they knew we wouldn't get recross. So, so if you ask somebody directly, did Bob ever pressure you to do anything, et cetera? And even if the witness would say no, if the government had evidence that they could use, they would come back and try to undercut that on their redirect. So basically, there were a couple of witnesses that I thought were dicey in terms of what the government could make them do or make them eat, based on what I knew from interviewing them and from the 302 reports. So with a couple of witnesses like Hazel, said no cross. They did their direct. They were sandbagging for the redirect, hoping that we would step into it and say he never pressured you or anything like that, et cetera. And so we just let it ride.
It's hard for a defense lawyer to say no cross, no questions. I mean, we're used to, we like to get up and go after these people. It's hard.
It is hard, particularly when we had done it with other witnesses that we were more confident about. But I understood if Hazel said, it didn't get to me, but I thought Bob was trying to pressure me to do something favorable for Johnny Williams, we're out of luck on appeal right there. We got nothing.
Right.
We have no appellate arguments, basically. So we were, as I said, I wanted to win the trial. I definitely wanted to win the trial, and we tried like hell to win the trial. But we knew if we got bad instructions that it was going to be exceedingly difficult to win the trial. So we wanted to make sure that we preserved these issues for appeal, which we did. And at the end of the case, the government wouldn't agree to bond pending appeal. Neither would the judge. We had to go get that from the Fourth Circuit. We had to, after the Fourth Circuit ruled against Bob, and by the way, on the Fourth Circuit, after the panel ruled against us, which are all Democratic appointed judges, recently appointed judges, or Democrats, we asked for rehearing in bank. 7 members of the Court of Appeals in the Fourth Circuit recused themselves because they were friends of Bob. So we got a really restrictive audience in terms of the rehearing in bank issue. And obviously the Fourth Circuit would not stay the mandate while we were going to go to the Supreme Court. So we ultimately convinced the Supreme Court to give us bond, or to stay the Fourth Circuit's mandate.
That's a pretty good sign.
It was an historic event. They had never given bond to somebody in the Supreme Court since David Trong in late 1970s.
I have to say, when I saw that you asked, I said this has 0% chance. It got reported that you had asked, obviously, and when the Supreme Court granted it, I was shocked, and I told everybody I've never seen this, and it's obviously a great sign for the governor. And you guys it must have been a huge day for you all. Governor McDonnell got bond in the Supreme Court. We'll hear about the oral arguments and the holding next and for the defense. Governor McDonnell lost a trial. He lost on appeal in the Fourth Circuit, but now he was before the Supreme Court. And the question before the Supreme Court was, even if he accepted all of these gifts from Johnny Williams, even if he and his wife accepted them, did he commit an official act, even if he did not take or pressure anyone to take any action on a government matter? He asked for jury instructions in the trial court saying things that merely arranging a meeting or attending an event or hosting a reception or making a speech is not standing alone an official act. But the trial judge refused to give that instruction, and the appellate court refused to say that it was reversible error. So we get to the Supreme Court, and Hank Asbill and his team for Governor McDonnell are saying that what the governor did was not a crime. And we'll find out how that turns out in For the Defense next.
Yeah, I think, and of all there was tremendous writing done in this case by a lot of great lawyers at Jones Day in particular, and that I played some role in, but certainly not complete the author of these pleadings. But a lot of appellate people that have been Supreme Court clerks were working with us on this, and the motion in the Supreme Court for bond was the best brief in the entire case.
So, Hank, what did the Supreme Court ultimately hold? Because I've read the opinion now a couple of times, and I'm still not 100% sure what an official act is.
They know one when they see one, right?
Yeah.
The essence of it from our perspective, or the way we tried to argue it in below, essentially, and in the Court of Appeals on all levels, was Bob had to put his thumb on the scale in terms of a decision, either that he made or that he tried to get someone else that he controlled or directed to make. Tell the health commission to do this, or tell this person, et cetera, to do something for Johnny Williams. All Bob did was give Johnny Williams access to various government officials, and he could make his pitch. If they thought it was a good idea, fine. If they didn't think it was a good idea, fine. If somebody wants to get a catering contract for the Bureau of Prisons, whatever, fine. I'll set you up with an interview. You go you make your pitch to them about why you ought to get the contract, and they make their decision. And Bob never did anything more than that in any context. And a lot of the things that he did were even much more innocuous, like inviting Johnny Williams to an event, to a reception at the mansion, that 250 invites went out and 125 people RSVP'd yes. And Bob didn't say anything about Johnny Williams or Nattablock or Star Scientific during this healthcare leaders event. And clearly, Johnny Williams was portraying himself as a chair of a public company engaged in developing products that were massively related to healthcare problems. That was his whole pitch.
And you get this great opinion then going through all of that, and it's really, the Chief Justice writes this wonderful unanimous opinion, but you get to the last paragraph.
Yeah.
And the last paragraph says, there is no doubt that this case is distasteful. It may be worse than that, but our concern is not with tawdry tales of Ferraris, Rolexes, and ball gowns. And then it goes on to talk about it. What did he need to write that at the end there?
I think he probably needed to write that to get unanimous opinion.
Yeah.
But obviously, from the oral argument, basically, I was convinced that we were clearly going to win, and I thought we would sweep it, which we did. So did Mike Dreeben, who argued for the government. He was completely deflated at the end of the oral argument, basically, this follows on the heels of the Supreme Court taking a half dozen criminal cases, each of which they reversed because the government was overzealous in terms of prosecuting people on theories that were real reaches or real stretches under vague laws that they had encouraged Congress to enact. And the ultimate pitch, basically, even during oral argument in the Supreme Court, was, leave it up to our discretion, and we'll be judicious about how we exercise it.
We'll do the right thing.
And yeah, we'll do the right thing. And they're looking at, like, well, excuse me, we've had 4 or 5 cases in the past couple of years where we've ruled that you haven't done the right thing.
Yeah.
And we've had to reverse those convictions because you all have overreached in terms of interpreting these vague statutes. There's a lenity issue here. There's a federalism issue here. The bottom line is that I don't think the government ever truly understood the nature of the job of being a governor. I don't think they understood the business of being a governor in ways that were realistic. And Bob had come into Virginia. You got one term by statute. You got one term. You can't run successively. So you got 4 years to do something without trying to run again for office. He's in the middle of the worst recession in the history of the state of Virginia at the time. His motto is Bob's for Jobs, trying to bring back the economy in Virginia. And if anybody said that they would bring a business to Virginia or hire people in Virginia or give money to schools in Virginia like Johnny was doing, fine, bring it on. I'm all for it, because that's my job here, is to try to reinvigorate the economy in this state. And the way, Bob goes to receptions, he's getting people approaching him all the time. Can you do this? Can you do that? Blah, blah, blah. And Bob says, call this guy in my cabinet or call that guy in my cabinet. His job was to say, yes, I can get you an audience. Their job was to say, no, your idea is bullshit or your idea is a good idea. But that wasn't his job.
And so what happened to the governor? He wins this case. He's free. He's a free man. What is he doing now?
Well, he's ultimately gotten divorced from his wife. He was back working with his old law firm in Virginia Beach, doing some legal work and some sort of rainmaking. He's writing a book that he's in the middle of that project as well, and he's going around, doing a lot of business, a variety of different kinds of business development projects. This is somebody who was on a short list to be asked to be vice president or possibly run for president in the Republican Party. Obviously,
we'd probably be in a lot better place if that would have happened. So,
and the other thing I want to say, though, is that the other sort of overarching strategy that we employed from the beginning was the use of amicus briefs. And we filed two amicus briefs in the district court, which the judge refused to accept and would not read, because he said, I don't have to. There's no rule or case saying I have to take the briefs. One from 5 former attorneys generals saying they would have told Bob, if they were his attorney general, that what he was doing was okay. And we also had the NACDL writing a brief, Harvard law professors, Nancy Gertner, Charles Ogletree, writing a brief about the official act issue. The judge wouldn't read them. We ramped that up to about a half dozen in the Fourth Circuit, and we ramped it up to about 11 amicus briefs in the Supreme Court, including one that Roberts found particularly compelling, which was an amicus brief by numerous former high-ranking people in the Justice Department, the Solicitor Generals, Deputy Attorney Generals, et cetera, both parties, all saying that, the government's interpretation of the law is wrong. And so that was one of the overarching strategies we thought about employing from the very beginning of the case, and we did. And the only time we got any real traction on it, however, was in the Supreme Court.
You rarely see the Supreme Court cite to amicus briefs, and Roberts cites the 2 right up front, and the one you mentioned obviously had a lot of impact on him. And I think part of it was that you had both sides, Republicans and Democrats, supporting the position. But I've used up a lot of the classroom's time. I want to see if the students have some questions for you. They probably have better questions than I do. So I'm gonna turn it over to them and let them ask some questions. And I think we have a couple minutes left if we can indulge you for a few more minutes, Hank.
Yeah, I want to make one final comment about the sentencing. I think this is something that, aside from putting on a lot of more character witnesses at the time of sentencing, because the judge restricted me in terms of how many he would allow me to put on in front of the jury, we filed a voluminous pleading at sentencing that had, maybe 400 or 500 letters, individual letters from people telling anecdotal stories about Bob McDonnell and the things that he had done for people. A very, very compelling presentation and story. And to ramp up the guideline score by says Bob had lied during his testimony in front of the jury. And the judge, so therefore he ought to get an obstruction enhancement as part of the sentencing, part of the calculus for the sentencing. The judge refused to accept that recommendation or that motion from the government, did not find that Bob had lied at all during his testimony. And I think that the judge knew that he had to give some respect to the jury for its verdict. But I think in his heart of hearts, he didn't really believe the jury arrived at the correct verdict. And so he gave Bob the 2-year sentence as opposed to the guideline sentence of 12 plus years that the government had originally requested. But that turned out great, obviously. But there were also strategic decisions at the time of the sentencing about whether or not we would move to recuse the district court judge. And I did not think had given us a fair trial or a fair pretrial. I made the executive decision that we're not going to raise this or bring this motion. And we need to play this right with this judge and play up the military service, play the religious, Bob's, obvious religious, character, et cetera, his general good character, and the fact that he was literally the most empathic person I've ever known in dealing with him for 1,000 hours. I never heard him say a negative word about another human being, including Johnny Williams, including the prosecutors, including the judge. And many of those folks, I had a lot of negative things to say about, but he would never engage in that.
I wasn't there, and I'm ready to say some bad things about Johnny Williams.
And he never did. He never did. But that's the kind of person that he is and was, and not a political bedfellow of mine in terms of conservative Republican, et cetera. But a very decent human being who I think generally always tried to do what he thought was right. And he was also, Bob is a greedy guy who wanted these gifts and shit like that. Bob had a car that had 200,000 miles on it. Bob's briefcase was a plastic milk crate. That's what he carried his papers around.
Okay, you're giving your closing argument again, Hank. We heard this closing already. All right, let me see what the students have to say.
I'm happy to stay as long as the
okay. Who's got a question for us?
You gotta love Hank's passion. He's still arguing for Bob McDonnell even before the students of my white collar crime class. But now the students have some questions. Feel free to listen. I've included them. They go on for about 15 more minutes, and it's pretty interesting to see the students' perspective and where they're coming from. And there's some interesting question and answers coming up next in For the Defense.
So my question is, now, in hindsight, we know now that the winning argument is the government's wrong about what constitutes an official act. The opening and the closing, like you said, really focus on his good character. But the government, their opening seems like their whole argument is, look at all this smoke, look at all the smoke, where there's smoke, there's fire. How did you, it sounds like your argument was more, there's no smoke, this is a great guy, there's no smoke. How did you come to that strategy rather than the government's wrong about what constitutes an official act? Why did you choose to keep trying to rely on his good character when even before the trial started, with the publicity, his name's already been smeared, the Ferrari, whatever. the jury already feels a certain way about his character. Why focus on that rather than the law?
Well, I mean, a couple of things. The jury is not going to decide the law. The judge is going to do that, or the Court of Appeals is going to do that. And we assume that because, we had motions to dismiss the indictment that were denied, that we were not going to get good jury instruction. So in terms of trying the case, we were not going to deny that there was this quid parade. There are a lot of things that Bob or his family got, some of which he knew about, some of which he didn't know about. But our position at the trial essentially was that, okay, he got these gifts, but he never did anything for Johnny Williams in return. And it's legal in Virginia for a governor to receive gifts, from people that want to give him gifts. And this is historically what every governor in Virginia has done. So, whether you like the fact that he's getting gifts, I couldn't deny that he got the gifts. I couldn't deny that he knew about a number of them. So it basically said, there's quid here, the undeniable quid. There's no pro for anything, and there is no quo. And so, where is the quo? Where's the return? Where does Johnny get what he wants, or where does Johnny get a promise to give him what he wants? And that never existed in the case. And so if the law is you got to have a quid pro quo, and there's no quo, whether you whether you're upset about the quid, so be it. You can be upset about the quid, and we got to acknowledge that looks terrible. It looks bad. It looks unseemly. But this is standard operating procedure in Virginia politics. And we had to try to overcome the press reports to the contrary, that this was something that, the quid alone made Bob guilty. So, we argued that legally they can't meet the quid pro quo test. Alternatively, the jury instruction is on character evidence, is that evidence of good character alone can create a reasonable doubt.
Did you get that instruction?
Yeah, we got that instruction. I got that instruction. So I wanted, and you really are looking at, what Bob knew, when he knew it, what was Bob's intent. And I wanted to both have the jury like Bob in terms of his character, and I was also setting this up for the judge at the time of sentencing if we lost. That's why I wanted, and I think, character, if you've got good character for your client, if he has a good reputation, it can be an extremely powerful tool in any kind of criminal case, particularly white-collar cases, where, interpretation of events, amorphous, cryptic things are at issue, or reflexive emails and things of that nature. And you've got to have, if the guy says, this is not what I meant, or this is what it says, but it wasn't what I meant, or I didn't know this, or I didn't know that, you got to believe the guy. And you got to want to help him. And so I was intent on putting on evidence of his good character to try to have the jury like him, have the jury want to try to save him, even if they had serious questions about whether or not he had done something wrong.
Okay, I got another question for you. Here we go.
Thank you so much for coming. My question is, I guess, relates to the influence peddling. There's no pro quo because influence peddling isn't an official act. Do you think the U.S. should criminalize that? Do you think we should tolerate a society where people think they can play only if they can pay? I'm just kind of curious what your thoughts are.
These are, the ultimate sort of reconstruction of the American political system is above my pay grade. This is the system we have. This is the system that, was in operation at the time. Would it be better if governors weren't allowed to take any gifts? Yeah. Would it be smarter if they didn't take any gifts? Yeah. Would the public be more inclined to trust them if they didn't? Of course. But that's not the way the system worked in Virginia or anywhere else in the country. And the bottom line from my perspective is that if you're going to criminalize some behavior, people that might get caught up in that have an absolute right to know where the line is. The government does not want to tell you where the line is because they're afraid that people will walk right up to it and get chalk on their toes. That's why the SEC, for example, and the government has never wanted to define insider trading in a way that is clear cut, because there's sort of interim effect by having vague laws and vague statutes. The government thinks serves their purposes better.
Trust us, Hank. Trust us. That's what they say. I got another question for you. Here we go.
So I think people generally don't like the idea of public officials getting gifts, even if it's not illegal. But it seems like you may have had to point that up for the purposes of the case. Did you feel like you had to cure against that at all?
I'm sorry. I'm sorry. I just need to hear it louder.
Come up here and shout it out. Hold on. Here we go.
It seems like generally people don't like the idea of public officials getting gifts, even if it's not illegal. But it seems like you had to play that up for the case. Did you feel like you had to cure against that at all? And if so, how did you do that?
Well, I mean, yeah. I mean, the public, no, I knew the public wasn't going to like it. I mean, that's why all the press was negative leading up to and throughout the course of the trial. I knew that it was going to be offensive to people that he had taken. I mean, the $170,000, 100 of it roughly was a loan that was repaid to Williams, and there were some other gifts, et cetera, to the governor, his wife, and his family members. I knew they weren't going to like it, but that wasn't the issue in the case. I mean, if the issue was did he get gifts and loans, yeah, we got no defense for that. But that the law doesn't criminalize getting that quid. And that's why Bill Burke, counsel for Mrs. McDonnell, asked the case agent after the quid parade at the end of the government's case, when they bring in every tangible item that was a gift to the governor or his family members. And, so Bill Burke gets up and he says, okay, you got a whole list of quid. Where's your list of the quo? Where are the things that Johnny's got? And the agent says, well, we don't have a demonstrative for that.
Oh, that's good. That's good. I love it. All right, we have time for 2 more questions.
So my question is what was your calculus going into deciding whether or not to try and sever Mr. McDonnell's case from his wife's? Because it seems like she had some particularly bad facts, especially the sales of the stocks and the timing with the filings that they were supposed to do, the financial disclosures.
Yeah, I'll tell you.
Thinking about the severance.
Good question. We filed a motion for severance of defendants. In support of that motion, Bill Burke, who was Maureen McDonnell's lead counsel, authored an affidavit that was 15 pages long, outlining what his client would testify to if she were called as a defense witness for her husband. And the exhibit was replete with examples of, I didn't tell my husband this, I hid that from my husband, he wasn't aware of this, he wasn't aware of that, on and on and on and on, et cetera. And telling why she held stuff back from him, et cetera. The judge would not. We asked the judge to read the affidavit on an ex parte basis, and there's case law supporting this proposition, and then to give us a separate trial. He refused to read the affidavit and denied our severance motion. But Mrs. McDonnell, had she been given a separate trial, she didn't want to testify in her own criminal trial, but was perfectly willing to testify in his criminal trial, whether hers was before his or after his. But the judge basically refused to read the affidavit because we wouldn't simultaneously give it months before the trial to the prosecution, because it would have been a roadmap to our cross-examination of a lot of the government's witnesses. So we had to make a strategic decision not to give it to the government, the ramifications of it.
Okay, we got one last question for you, Hank.
Hi. So this actually kind of works out perfect because it's sort of chronological to what's going on. But once you realize that it was going to, go together in the same trial, the 2 defendants, how much collaboration went behind the theory that was put together for Bob as being separated from his wife at the time? And then on top of that, did you ever have any ideas for theories that were more collaborative, kind of like including the facts from her side?
Well, yeah, I mean, there was definitely a coordinated plan between the parties here, between our lawyers and Mrs. McDonnell's lawyers, and I mean, the press kept reporting it constantly as though we're throwing her under the bus, and even her own lawyers are throwing her under the bus, et cetera. One blogger who seemed to understand what the hell was really going on in the courtroom said, it appears to me that what they're really doing is driving the bus together. And we were. I mean, we couldn't get around the things that she had done that were unseemly and that we didn't know about it in real time, basically. We couldn't get around those facts. We had to deal with them. And basically, as I said at the beginning of this, the way we chose to deal with them was let's tell the truth about the marriage. The government's basic theory was these people conspired, and the proof of that is that they were husband and wife. And our facts were, yeah, they're husband and wife, but it's a totally dysfunctional marriage and relationship, and they're not really sharing anything with each other. And if Bob knew about some of the things that Maureen was doing with Johnny Williams, he'd have been apoplectic, but he didn't know. And he was too busy and too preoccupied with affairs of state to deal with it. And he didn't have the bandwidth to argue with his wife, at midnight every night when he was doing, 16-hour days being the governor. So anyway, we tried to coordinate these things as best we could. It wasn't my plan, but her own lawyer, Maureen's own lawyer, basically argued that she had an infatuation, with Johnny Williams and was, had a platonic relationship with Johnny Williams. That was not my argument, but that was her own lawyer's argument, but that was not something that was coordinated with us. That's just the way it played out. There was a lot of coordination and trying not to hurt each other, for sure. But Bob and his wife had different counsel, and they sometimes went off in different directions, planned or unplanned, during the course of the trial. But this is always a problem when you have co-defendants, always. And you had a much better chance if we could have gotten a separate trial, and we didn't have her there in the trial, basically. And if she could have been a witness for us, it would have been exceptionally helpful. But she was not willing ever to take the stand in her own defense.
So, Hank, I just wanted to thank you. This was awesome. It was so nice to speak to a real criminal defense lawyer who fought, went all the way to the Supreme Court and won. It's such a great story. And so I just wanted to thank you and give and really appreciate the time and everything that you put into this. It was wonderful.
My pleasure, David. I enjoyed it very much, and I hope you all enjoyed it as well. And I'm sure you're going to have a lot of fun in David's class for the rest of the year.
Really, really interesting to hear about the representation of a sitting governor who was considered for a vice presidential slot and who had everything going with him, and then had to deal with a snitch named Johnny Williams discussing what ended up not even being a crime, and his whole career was derailed. It's truly unbelievable how our United States government sometimes overreaches, especially in the federal system with white-collar cases. This was a fun bonus episode. Season 2 is coming up in a couple of weeks, and to kick off season 2, we have Alan Dershowitz, Professor Dershowitz from Harvard Law School fame, and we'll be talking about the O.J. Simpson trial. I'm very excited to speak with Professor Dershowitz. I'll see you all in a couple of weeks. Enjoy the holidays. Thanks.